Okay, so my screen is visible, right?
Yes,
Okay, so we'll start. Okay, so we have to start from June, May, April. So we have to start from March. Okay, so just remember we are starting from March today. So this section. Okay, so we'll start. Visible, right? This one. Okay.
it's visible.
Okay, so the writ jurisdiction under Article 226 can be invoked to quash FIR if it is found to be abusive of process of law. Okay, so again, this article is coming up to 26. So in this, Supreme Court is telling that it can be invoked. Okay, 2226 can be invoked to quash FIR if it is found to be abusive of process of law. So even they can quash an FIR if it is found to be abusive of process of law. Okay, so I think broadly, I'm not sure if no specific thing has to be remembered, but we must just know that even an FIR can be quashed if it is found to be abusive of process of law. Okay. I mean, nothing to be remembered as such. Okay, I guess. Okay, so we'll move on. Next, systemic fraud or irregularities make entire selection process illegitimate. Okay, so I think this I have seen in newspapers also. This was in news because of in the lower level selections, whatever happened, there's no systemic corruption involved. So systemic fraud or irregularities make entire selection process illegitimate. So SC upholds cancellation of examinations by Delhi Subordinate Service Selection Board. Okay, Delhi SSB ka it has upheld the cancellation because there was systemic fraud involved. Okay, but I don't think such thing might come up.
Yeah,
Okay, so
okay.
we'll move on. This is important sedition. Okay, see this I had told also in group. So this is a standard code we can use and answer directly. So not seditious to have views different from government. Okay, so this we can directly use. So SCA dismisses plea against ex JNK CM Farooq Abdullah for his remarks on Article 370 with 50K cost. Okay, so basically this Farooq Abdullah, he made a statement that if you see, he said that hand over Kashmir to China, something he said. Okay, Farooq Abdullah. So then sedition case was put up upon him, and then Supreme Court again said the same thing, the sedition issue. It is not seditious to have views different from government. So this we can use directly in mains. Okay,
Yes.
nothing
One
much.
essential sentence was there that when one attempts to violently overthrow the government, then only it's
Correct,
sedition.
correct.
Yeah.
Yeah, so in that case, it is sedition. Okay, so remember the cases, Kedarnath case, and even think there's one more Balwantra, some cases there, 2015. Okay, so those, and recent the Vinod Dua, Vinod Dua, that journalist case also, that is also important. Okay,
Yes, yes.
so we'll move on. I think here sedition is important, largely from mains. Okay, a dying declaration cannot be discarded. A dying declaration cannot be discarded merely because relatives of the deceased were present in the were present in hospital while recording it. Okay, I mean, it's related to that euthanasia thing. I believe
Mercy killing.
Hmm. So it cannot be discarded is what it is trying to tell. Okay, I mean it's very intricate thing which I don't think is important for exam. Okay, we'll move on. Next, I think this is again connected to that larger issue of reservation. Okay, this was another judgment, but I think most of us might have not heard this. Okay, just see this carefully. OBC reservation cannot exceed 50%. Okay, this we already know. I mean, general reservation cannot exceed 50%. We know, but if you see the specific case, OBC reservation cannot exceed 50%. SC reads down this section 2 of Maharashtra Jilla Parishad and Panchayat Samitis Act. Okay, this Maharashtra, two things are connected. That Maratha thing, and this was another judgment. No, just this was in March. So I'll just read this fully. SC read down section 2 of this Maharashtra's Jilla Parishad Panchayat Samiti, which provides reservation of 27% to the of seats in Jilla Parishad. Okay, this act provided 27%, but reservation in favor of OBCs in the concerned local bodies can be notified to the extent that it does not exceed aggregate 50% of the total seats reserved in the favor of taken together. I think that it's the same thing, now that Indira
Huh.
Sawhney they're trying to tell again,
Yes.
reaffirm again. Okay,
Hmm.
nothing new. So we'll move on. So if you see this, aim of every court is to discover the truth. Okay. So aim of every court is to discover truth. Yeah, obviously. SC expands the scope of Section 311 of CRPC. I'm not sure till date UPSC has not asked any CRPC or IPC
Hmm.
sections in exam. Okay, but you never know. Just if possible, try to look up 311. But I don't
Huh.
think it's required. My
It's
personal
not
opinion.
important.
Okay.
Hmm.
Okay, let's move on. And it's not even connected to any fundamental rights or any such. Okay, so we can skip this. Next, we'll move on. A reservation against candidates, sorry, reservation category candidates who make it on their own merit have to be adjudged against general category. Okay, so SC reiterates the old standpoint. SC is trying to reiterate. So if any reserved candidate, if he makes it on his own merit, have to be adjudged against general category.
Means he will not be counted in the reservation list.
Correct, correct.
Hmm.
Right. So the principle that, if you see this quote, the principle that such a s- the principle that such of the reservation category candidates who make it on their own merit have to be adjudged against the general category has not been in doubt. Okay, I mean this is the same principle, no, which he is using time and again. Okay, so we'll move on. Time is a crucial facet of the scheme under IBC. Okay, resolution applicant must be fair in its dealings. So again, IBC is back into the news. Okay, so maybe I'm not sure. Only if you can revise IBC, that would be sufficient, I guess. Okay, time is a crucial facet of scheme under IBC. It's trying to tell. So I'll just read this case. In this case, national NCLT. So NCLT also try to look up again. Uh, allowed the liquidation of corporate debtor to proceed. Okay, upholding this order, NCLAT, so National Company Law Appellate Tribunal, observed that applicant had failed to implement the resolution plan for a period of over 8 months. Okay, so this was what they identified. In appeal, bench comprising Justice so and so noted that sufficient opportunities were granted to the applicant earlier during the pendency of the proceedings, both before both before the NCLT and NCLAT. Okay, these two tribunals, I think we must know something about them. Okay, the orders of NCLT and NCLAT make it abundantly clear that despite the grant of sufficient time, the appellant has not been able to comply with the terms. Okay, fine. I mean, all this nitty gritty we don't need to remember, but let us start to
Ah,
revise more on IBC, NCLT, and NCLAT. Okay, we must have some clarity on this. Okay,
ah,
we'll move on. So, fed up of seeing cut copy paste orders of High Court. Okay, independent reasons need to be cited. This I remember. See what happened now. In many cases, High Courts, they try to cut copy paste the orders. Okay, they don't give reasons as to why they are giving such a judgment. Okay, so Supreme Court, again, it's coming down heavily on the High Court. So they must also cite reasons. So I'll just read these statements. One of the problems of the computer age is copying and pasting of orders. Okay, so you can remember broadly. I'm fed up of seeing cut copy paste orders of High Court. Okay, this was said by Chief Justice Chandrachud. So independent reasons have to be cited for reaffirming an order. Okay, there has to be an independent application of mind. Cut copy paste from the tribunal judgment only adds to the voluminous pages but does not answer the core issue of the appeal. So they must reason out. Just like how Supreme Court gives reasons, they must also reason out. This is what he is trying to broadly hint. But I don't think any specific is there. But if you see, there's one article coming up here. Okay, Article 320. You're aware Article 320?
is it?
Sorry, I didn't get you.
I do not remember it.
Okay, I was just checking up. Okay, Article 320 is functions of Public Service Commission. Okay,
Okay.
nothing related to
Ah,
the case, I
three.
believe. Okay, 320 is
Service.
functions of Public Service Commission. Okay.
Okay.
So we'll move on. I mean, in this case, what had happened was Justice Chandrachud and Shah noted that it is the UPSC rules under Article 20, okay, Article 320, and not the DOPT rules, which would hold for. Okay, okay, so nothing no, important. Okay. Article 320 is just coming up here. We'll move on. Next is magistrates and trial judges also have responsibility in safeguarding citizens' fundamental. See, this fundamental is coming up. Okay, so it's let's read this. So magistrates and trial judges also have responsibility in safeguarding citizens' fundamental rights. So it's like everyone has a responsibility, not only Supreme Court. In that sense, I think it's trying to. If you see this thing, magistrates and trial judges have as much, if not more, responsibility in safeguarding the fundamental rights of citizens of India. As the highest court of this land remarked, okay, this also in a judgment which emphasized the role of lower courts. So again, the lower courts, no, the role it is emphasizing in preventing abuse of criminal court
Here
process.
article 32 and 226 become important.
Correct, correct. Okay, so this is a case that should not have been allowed to reach as okay. It's telling that no such cases, petty cases, should not come up. Okay, so it has come up to Supreme Court if you see in that sense. So I mean, again,
I
contributing.
think what they used to do is not
Hmm.
as soon as they see fundamental right, they forward it for like Supreme Court. If this
Ha.
is not in my jurisdictions, so Supreme Court is reiterating nahi, that even you can make
Right,
judgments on this.
right. So yeah, this line of thought also we must remember. Okay, so we'll move on. SLP filed. Okay, SLP, specially petition article. You remember, right? 136. Okay, so SLP.
136.
SLP filed only against the review order of High Court, not maintainable. Okay, so just read again. SLP, which is filed only against the review order of High Court, is not maintainable. So what does this mean?
This is about this is not about original jurisdiction. Na? In SLP, I think SLP filed only against review order.
Of High Court, okay, not maintainable.
Hmm.
So such an SLP is not maintainable. It is trying to tell. Okay,
Hmm.
let us read further.
Okay.
A bench comprising so and so reiterated that special leave petitions filed against the order of the High Court in review petition is not maintainable. Okay, let us read this. In this case, the special leave petition against the substantive order were dismissed in 2010 without any liberty to file a review application or approach the apex court again. Okay, thereafter, the review applications were filed before the High Court, which were dismissed. Okay, against this dismissal of review petition by the High Court. Okay, see, I think when once the review petition was dismissed, na in High Court, they have directly gone to SLP. So this it is
Okay,
trying.
they should
Ha,
okay, they should appeal to the Supreme Court
ha,
first
exactly,
and then
exactly.
use okay, because SLP is the last resort, no?
Correct.
Hmm.
So
Okay.
SLP for review is not a thing. Is not a procedure. You cannot do that. Okay. So it is now open to the petitioners to seek leave of this court to file SLP. Okay. I mean it's the same thing. Okay. Just remember this. The SLP stands dismissed. Okay. Fine. In this case, SLP we cannot do. Okay. Just remember this. We'll move on. A single bench. Again, if you see, 142 is coming up. Single bench hearing transfer petition cannot invoke Article 342 to pass a decree dissolving marriage by mutual consent. Okay, I mean, I think very specific to this case. I think again, I'll read the single bench hearing transfer petition. They cannot invoke 142 to pass a decree
Um,
dissolving marriage by mutual consent. So I think uh,
142 is for complete justice, no?
exactly. They
Like,
had asked last year also
hmm.
this article. So SC
Hmm.
observed that its single bench, while hearing a transfer petition, they cannot invoke this thing to pass a decree. So what has happened is in this case, parties, husband and wife, to a transfer petition before the SC filed a joint application for divorce. Okay, they had filed a joint application for divorce by mutual consent. Okay, so they've normally filed for divorce by
Hmm.
mutual consent of the parties. They requested the court to invoke. See, they have
Okay.
requested the court to invoke 142
Huh.
of the constitution and to dispense with the compliance of some of the procedural formalities and timeline. Okay, there's some timeline. Okay, in this act.
Okay.
So
Huh.
I think they're in a hurry to get divorced. So maybe
Huh, huh.
something like okay.
Hmm.
The transfer petition was filed by the wife seeking transfer of the divorce petition filed by the husband from the family court Pune, Maharashtra to this so and
Hmm.
so. Okay, I think they want to speed up the process. Something regulation is coming in the way, so they just jump to Supreme Court. This is not
Supreme Court, yeah.
Supreme Court
Okay,
will
huh.
not use such a power to such things. Okay,
Hmm.
broad thing. Okay, nothing specific, I believe. But just look up 142 again. SC asks government employees holding the post of state election commissioner to this is important. Okay, this is very important. Okay, just a minute. So Supreme Court is asking government employees. See what is happening now. If you see in many states, state election commissioner is one who is already a bureaucrat. Okay, so
Yes.
that should not happen. So SE asks government employees holding the post of state election commissioner to immediately step down. Okay, this judgment is
Okay.
important. So I'll just read this. While holding the while holding that, serving government employees cannot. Serving government
So,
cannot simultaneously function as elections because election commission requires no independent that free and fair mode. Okay, so cannot serving government employees cannot simultaneously function as state election commissioner. Okay, also gave a categorical direction. Okay, that such officers should immediately step down. Okay, so this is the thing. The court passed this important direction in exercise of they have used this power. to give that judgment
Okay, 140.
again. So if you see, to ensure that this is the quote, okay, to ensure that constitutional mandate of an independent state election commission, which is to conduct elections in under Part 9 and Part 9A of the Constitution, be strictly followed in the future. Okay, again, the independent nature of election commission has to be maintained, so you cannot be associated with the government. You step down, is what it is trying to tell. Okay, so this is the thing.
They have not made any suggestion that who can take up the post then. Pay scale. ठीक है, okay.
I think serving should not be there. Retired, those things should be fine. Okay,
Okay.
serving should not be there because of that. No bias, conflict of interest, all those things. I think we must for this we must revise state election commission thoroughly. Okay, um,
One more case was there yesterday. This is important.
state election commission we must look up again. Okay, so we'll move on. See, this is again related to 226. Writ petition under 226 not maintainable against orders passed by State Consumer Commission. I think this is also important. So, as we know, consumer courts also do some appeals. So, if you see writ petition under to not maintainable against the orders passed by State Consumer Commission. Okay, so this is important. A bench of so and so opined that writ petition under 226 challenging the judgments and orders passed by State Consumer Redressal Commission is not maintainable. So again, no, it is trying to curtail the 226 wala writ jurisdiction. See, we know broadly know that 226 is very wide. So people trying to use this again and
Yeah.
again. So AC is
This
trying to
is unnecessarily increasing the number of cases,
correct,
and they want the consumer tribunal to be the final authority.
correct. Otherwise, there's no purpose of setting such redressal body.
Right.
So this quote I'll read up. Okay, we cannot help but to state in absolute terms that it is not appropriate for the High Courts to entertain writ petitions under Article 226 of the Constitution of India against the orders passed by the Commission. Okay, this viewpoint is important, as a statutory appeal is provided and it lies to this court under the provision of this Consumer Protection Act. Okay, once the legislature has provided for a statutory appeal to a higher court, it cannot be proper it cannot be proper exercise of jurisdiction to permit the parties to bypass the statutory appeal to such high court and entertain petitions in exercise of its powers under. Okay, I think broadly you got the line of thought, right? So just try to revise Consumer Protection Act again. Okay, Consumer Protection Act and its appeal mechanisms. Okay, this becomes important. 226 cannot be this condition. Okay. Anyway, we have discussed if such a statement comes up, we can eliminate. So we'll move on. Impart gender sensitization training to judges. Okay, include such courses in LLB, AB syllabus. Okay, I think this was very much in news. Judges were passing some stereotypic sexist remarks in their judgments. So because of this, Supreme Court was compelled to make this statement. Okay, so I'll just read this quote. Okay, the National Judicial Academy is hereby requested to devise speedily the necessary inputs which have to be made part of the training of young judges, okay, as well as part of the judges continuing education with respect to gender sensitization. I think many even Hindu articles editorials had come up on this with adequate awareness programs regarding the stereotyping, unconscious biases. Correct. We all are, we are living in a patriarchal society, so this will happen. That can creep into the judicial reasoning. The syllabi and the content of such courses shall be framed after necessary consultation with sociologists and teachers in psychology, gender studies, and other relevant fields, preferably within 3 months. Okay, so it's broadly you try to use such things in mains. Okay, we'll move on.
Systematically.
Okay, so we'll move on. So next is Prevention of Corruption Act. Okay, prevention of this act is come. Prevention of Corruption Act. An inquiry at pre-FIR stage is not permissible. It's not only permissible but desirable. Okay. Okay, Prevention of Corruption Act has come up. Okay, an inquiry at pre-FIR stage. Okay, prior to FIR, is not only permissible but desirable. So he must do a pre-FIR inquiry. Okay.
Maybe people just file the cases, no? So in order to reduce the case,
Right. So
first you investigate and then file FIR.
correct.
Something like that.
So it's not only permissible but desirable. Okay. So just I think from this perspective, we must try to revise the latest Prevention of Corruption Act amendment completely. Okay. I think Vision had covered it holistically. That latest amendment with all the pros and cons. Okay. That we must look up from the static or whatever point of view. And let's read this quote quickly. Um, An inquiry at the pre-FIR stage is held to be permissible and and not only permissible but desirable, more particularly in cases where the allegations are of misconduct, of corrupt practice, acquiring the assets properties disproportionate to his known sources of income. Okay, that's what Prevention of Corruption Act is meant for. After
Yeah.
inquiry at the pre-registration of FIR stage, if on the basis of the material collected, okay, in such inquiry, it is found that complaint is vexatious. No, it happens normally against bureaucrats, they do, and or there is no substance at all in the complaint, the FIR shall not be lodged. Okay, just check and then file FIR is what it's trying to say. Okay. However, if the material discloses prima facie a commission of offence alleged, the FIR will be lodged and the criminal proceedings will be put in motion. Okay, fine. I mean, broadly, it is trying to lay down some regulations. Okay, nothing less, but just to try to revise the Prevention of Corruption Act. Okay, thoroughly. We'll move on.
We can also use in ethics cases. Okay.
Exactly, exactly. Correct. Okay, we'll move on. So you see, if you see I think this is important from society perspective. Okay, not sure from prelims, but society structures of our society created by males for males. Okay, that's what we were discussing. The patriarchal society. We can use this quote in patriarchy women question. Anything comes up. Okay, so SC holds army's evaluation criteria to grant permanent commission for women officers arbitrary. Okay, so we are running in such a society where males are creating for males. That patriarchy is perpetuating. Okay, so just a minute. Huh. So you'll read this.
Okay. Yeah. A division bench comprising of Justice D.Y. Chandrachud and Justice M.R. Shah declared that the evaluation criteria adopted by the Indian Army to consider the grant of permanent commission for women officers to be arbitrary and irrational. Okay, they were giving the less important post, something like that. The court directed the army to reconsider the plea of women short service commission officers for the grant of PC within the PC within the 2 months in accordance with fresh directions issued by the court.
PC is
Okay,
permanent
the
commission.
top
Okay.
permanent council. The top court held that the evaluation criteria adopted by the army to benchmark the women officers with lowest credentials of their male counterparts and to freeze their ACR evaluation at the fifth of the 10th years of their services to be arbitrary and irrational. Okay, this is done.
Okay. Okay. So, I mean, if you see the reasoning, they've given this can be used, I think, in some ethics or essay. So, I'll just read this out. We must
Yeah.
recognize here that the structures of our society have been created by males for males. As a result,
Hmm.
certain structures that may seem to be norm, may appear to be harmless, are a reflection of the insidious patriarchal system. Okay, this we might not know, but such a criteria,
Hmm.
right? At the time of independence, our constitution sought to achieve a transformation in our society by envisaging equal opportunity in public employment, and equal gender equality. Since then, we have continuously endeavored to achieve the guarantee of equality enshrined in our constitution. A facially equal, if you see here, a facially equal application of laws to unequal parties is a farce. Okay, I mean, such thing we can use when the law is structured to cater to a male standpoint. Okay, so this is the point. Superficial face of equality does not stand true to the principles enshrined in the constitution. Okay, so these things important. Okay, let's move on. This judgment, I think, that remains ethics, GS1 society. Okay, move on. Call for justice. Call for justice, not hate speech. Okay. So again, fundamental rights has come up. Okay, this
Okay.
is important. Okay, you can read this.
Yeah. Uh, okay, where the important lines are. The whole thing. I think we should filter just the important sentence. The court allowed the appeal filed by um, Mukhim challenging the Meghalaya High Court. India is a plural and multicultural society. The promise of liberty enunciated in the preamble manifests itself in various provisions which outline each citizen's right. They include the right to free speech, to travel freely and settle subject to such reasonable restrictions. Okay, Article 19. At time when in the legitimate exercise of such a right, individuals travel, settle down or carry on a vocation in a place where they find conditions conducive, there may be resentment, especially if such citizens prosper, leading to hostility or violence. In such instances, if the victims voice their discontent and speak out, especially if the state authorities turn a blind eye or drag their such a voicing of discontent is really a cry for anguish for justice denied. Federal structure, wala. This is exactly what appears to have happened in this case. Call for justice, not hate speech.
Call for justice, not hate speech.
Okay.
Okay.
Acha, it says over a Facebook post on violence against the tribal people in Meghalaya. The
Hmm.
court noted that the Facebook post was apathy shown by the chief minister of Meghalaya. Okay, they are saying that we should provide justice to such people rather than enhancing
Booking
the
them under hate
hate.
speech.
Hmm. Hmm.
Okay. Okay. Okay, I think yes. Now, even in COVID times, I think this was happening. Maybe that they were posting something on all the social media, and they were imposing some IT rules. All these things were violated. Okay,
Ah, hmm.
was direct against the apathy shown by chief. Okay, okay, so that is not a hate speech. It is just showing your apathy. As a CM, you should act more empathetic.
Yes.
Okay, fine. So I think it is 7:30. We were just able to complete 1 month. Okay, so we'll stop here. Okay, 7:30. Huh? Right. So we have completed only March today. Okay, maybe
Oh God.
because of
Maybe tomorrow.
huh.
Hard.
Okay, fine. We'll end for
Fine.
today. Okay. Yeah.
ठीक है.